reforms lies not in their design, but in their implementation. We must therefore ask ourselves, are investigations concluded within reasonable timeframes? Are prosecutions being conducted with diligence and preparedness? Are courts managing cases proactively? Are institutions sharing information effectively? The answer to these questions will determine whether the promise of the framework and guidelines translates into real impact. As the judiciary, we are committed to strengthening our specialized anti-corruption courts, enhancing case management systems, and ensuring that corruption cases are adjudicated with integrity, independence, and efficiency. But success requires the full commitment of all actors, investigative agencies, prosecutors, defense counsel, and supporting institutions. Each link in the justice chain must function optimally for the system as a whole to deliver results. Equally, we must continue to address structural challenges, capacity constraints, legislative gaps, and emerging forms of corruption that demand new investigative and adjudicative approaches. Ultimately, the fight against corruption is not merely institutional, it is ethical. It is calls upon us to uphold the high standards of integrity within our respective mandates. The framework provides the roadmap. The guidelines provide the operational tools. What remains is sustained commitment, coordinated action, and accountability for results. Let us therefore use this workshop not only to reflect, but to recommit to a just system that is efficient, transparent, and worthy of the trust placed in it by the people of Kenya. In so doing, we affirm that corruption has no place in our institutions and that justice, timely, fair, effective, will prevail. With those remarks, I'm now honored to declare this workshop officially open. I thank you for your attention. Signed, the Honorable Justice Martha K. Koome, EGH, Chief Justice and the President of the Supreme Court of Kenya, delivered by Honorable Justice Mwaniki Gashoka, Judge, Court of Appeal. Thank you.
We can all appreciate the CEO, the chair, and the chief guest. Thank you for those remarks. Our workshop is now officially open. The media, they have requested me that you pause in your respective seats. They take what they call cover photos. So give your best smile. Are we good? Okay. Thank you for that moment. Allow me to request the CEO, the chair, to come forward and present just a small souvenir to the chief guest and take a photo. Farida, bring the souvenir. I am reliably informed that the souvenir is less than 20,000 Kenya shillings. Yeah. Yeah. You can go towards the middle. You can put him at the middle. Yeah. Then put him. Then you remove it. That's okay. Thank you. Thank you. Farida. Now, at this point, we are going to have the first presentation of this morning, and that particular session will be moderated by the Vice Chairperson of the Commission, Commissioner Dr. Monica Muiru. Dr. Monica Muiru is also the chair of the Support Services Committee of the Commission, and is also a member of the Enforcement Committee. Welcome, Vice Chair, to welcome the resource person. Thank you.
Chief Guest, Honorable Justice Mwaniki Gashoka, Judge, Court of Appeal, Honorable George Murugara, MP for Tharaka, and Chair, Justice and Legal Affairs Committee, Bishop Dr. David Oginde, Chair, EACC, distinguished guests, allow me to ride over the protocols outlined earlier. Good morning. Wangari Maathai once said, when the government is not transparent, it creates a culture of secrecy and corruption. And leaders must be accountable to the people they serve, not just their own interest. Today we are honored and privileged to have Honorable Murugara take us through the topic strengthening public accountability, enhancing parliamentary oversight in combating corruption. Allow me to say something about Honorable Murugara. Honorable George Gitonga Murugara, CBS, MP, Member of Parliament for Tharaka constituency in Tharaka Nithi County. I wanted to get that right. He has been an advocate of the High Court of Kenya since 1993 and a partner in Hamilton, Harrison, and Matthews advocates before he joined politics in 2016. He holds a Bachelor's of Law degree from the University of Nairobi and a postgraduate diploma from the Kenya School of Law. Since the 12th Parliament, he has served in the National Assembly's Justice and Legal Affairs Committee, in the Committee on Delegated Registration, where key registrations and regulations were passed. He is currently the chair of the Departmental Committee on Justice and Legal Affairs, where he oversees the entire governance, justice, and law and order sector. He is a respected human rights and constitutional law champion and a litigator of distinguished record. Ladies and gentlemen, join me, welcome to the podium, Honorable George Murugara. Karibu sana.
Thank you very much, Vice Chair, for those accolades. I don't know how much of it is true and how much is not, but that's a story for another day. The chief guest, my very good friend, Mr. Justice Paul Mwaniki Kashoka, the chairperson of the EACC, another very good friend of mine, the Bishop, Reverend David Oginde, the judges of the Superior Court, Justice Muteti, whom I've known for many years, and Justice Musyoki, again another gentleman I know, the magistrates of the lower courts who are here, the CEO, another very good friend of mine, CEO of the EACC, everybody, ladies and gentlemen, all protocol observed, good morning. As you've heard, my name is George Gitonga Murugara. I'm a member of Parliament, the National Assembly, and I represent the good people of Tharaka in Tharaka Nithi County. I must start by apologizing that we have editorialized the program because I'm available now, but will not be available in the afternoon. My session is scheduled for 2 p.m., but at 2 p.m. I have another session regarding all of you, possibly, or majority of you, before the Budget and Appropriations Committee, where we have to present reports on the supplementary budget, which affects most of the agencies that are here, and I'm happy to see all of them, and I need to be there, so that the little there is, I ensure I defend for you, and I'm able to carry out my mandate under Article 95 of the Constitution. Then after that, I have to go to Malindi, where we joined another team that went there yesterday to do public participation on a bill called the Public Participation Bill. This we have to do public participation on the public participation, because we are trying to enact an act of parliament which will deal with the public participation, a very important aspect of our constitution and the laws, and it's important that we go around the country collecting views. Those many remarks, I'm here to say something little about strengthening public accountability, enhancing parliamentary oversight in combating corruption. As the chairperson actually said, in Kenya, corruption is described in very grand names, including it's a dragon. I don't know what dragons were, must have been dinosaurs. We don't have dragons today. But they are all over the history and religious teachings. They must have been feared by human beings. So I'm 100% sure the reason we call it a dragon is because we fear it. And sometimes when we want to make corruption to look extremely ugly, you say it's a mongrel, that ugly dog, which nobody wants to face. With all that, Parliament has a role to play, especially when it comes to combating corruption. And the mandate of Parliament is drawn from Article 95 of the Constitution, and especially in respect of the second house, because there are two houses of Parliament, the National Assembly and the Senate, and I can never tell which one comes first, but from the Constitution is the National Assembly that comes first, followed by the Senate. So the role of the National Assembly is representation. That is why we have to go through elections, which are coming next year. And as again the chairman has said, it looks the country is live. It's like we are doing those elections tomorrow, but we still have more than 1 year to go. So we will do elections and we will have representatives elected because we all cannot go to Parliament. We have also to do legislation, which is to make the laws for the country. It includes all laws, including regulations. Every piece of law that has force in the country, legal force, must go through Parliament, both substantive and subsidiary. That's where you are told I sat in the Committee on Delegated Legislation in the 12th Parliament, where we were making regulations for the country, which is subsidiary legislation. We also have to do appropriation, which is what I'll be doing this afternoon, to try and distribute the little resources that are available to the various government agencies. And for me, it is going to be the governance, justice, and law sector. And the majority of those agencies are here. And finally, we have to do oversight, which is to ensure that we take care of the way the agencies exercise their constitutional and legal mandate, and also how they spend the scarce government resources, or public resources, not government, scarce public resources that are available and to the benefit of the citizens. Everything we do is to the interest of the people of Kenya. We hold them in priority, and that is why we have to hold you to account. And the people of Kenya have also to hold us to account as members of Parliament, because that is why we have to do regular elections, in which possibly 70% of us are ordinarily shown the door, because you may not have done your work properly. Now, parliamentary oversight is a fundamental pillar of the administration of justice in the criminal justice sector and is exercised in the following ways. As far as Parliament is concerned, this is what we do. Number one, we oversight the budgets and the expenditure of the agencies in the criminal justice sector. And we have named all of them. They include the judiciary, represented by the Chief Justice through the Honorable Justice Mwaniki Gashoka. The ODPP, which is supposed to be represented here by, I think I saw Joseph. Good. ESCC itself. ORPP, CAJ, Witness Protection, Kenya National Commission on Human Rights, the Office of the Honorable Attorney General, State Department of Justice, etc. All these are in that sector. We have to oversight the budgets that are given to them so that we see how you utilize the funds, is it for the good of the people, and whether there is any elements of criminality in what is done. Additional financing oversight is another role we play. And here what we do is you move away from justice and legal affairs, which appropriates, to some committees which are reserved for minority. Their work is to ensure that accounts are given and especially to scrutinize what the Auditor General does. So those committees include the Public Accounts Committee, the Public Investments Committee, etc. And they deal with those reports. That's why you hear it doesn't sound very exciting to appear before those committees, because some of these Auditor General's reports have queries, and those queries may not be very pleasant. The third thing we do is conducting approval hearings and vetting of nominees for appointment as leaders of the agencies. Some of the big men seated here, we actually conducted vetting for them, including the chairperson. Not a very pleasant experience. But we were a little bit soft on him because he's a good man. So I don't know how he took it. The CEO took it before us, and we had to take you through the exercise. The DPP, the Chief Justice, every one of them, it's part of the checks and balances system, so that the three arms of government can actually check one another. So the idea is to ensure that you get the best of the best. And I hope we were right, because so far so good. If we weren't, it wouldn't have taken this long. We would have known about it, and we say, so far so good. You are doing a good job at ESCC and the other agencies, and we encourage you to continue doing that good work. Then we have to do the oversight of performance of the agencies in the criminal justice sector. Again, we are mandated to do this by our standing orders, and this is where we have to assess from time to time. We usually meet these agencies to see what they have done in 1 quarter, half a year, and annual. So it is in regard to your mandate as an agency. It's also in regard to the funds that are appropriated to you on what you have exactly done. Again, that's one way of conducting our foundational pillar on administration of justice in oversight. The fifth one is committee inquiries. Again, the ones we were talking about, which are not very popular, but constantly we have to invite you. You have to come before us, and as Parliament, you have to answer those questions. And once you answer the questions to our satisfaction, you are fine. If you do not, to our satisfaction, sanction is meted out, and the sanction must be carried out. While we are doing this, we take the position of a quasi-judicial organ. We are not a judicial organ per se as Parliament, but we transform ourselves into some form of a high court where we have to make inquiries and then make recommendations. Then the last one is legislative intervention. And this is where you come in, you see the loopholes in what you execute as agencies, and you make recommendations. Our work is to legislate, put into place the laws that would help you execute your mandate. It's good I cite one we did recently. It's called the Anti-Money Laundering and Combating of Terrorism Financing Laws. It was an amendment bill, but it's an act of Parliament, 2025. We are trying to strengthen the anti-money laundering laws to ensure that we do not have money coming into the country, proliferating into the country, and this money cannot be explained. Where this happens, ESCC is up to try and ensure a solution is found. I know there are conflicts because the DCI too would start doing investigations away from this. You may find the asset recovering agents also trying to do something regarding money laundering. But all in all is to try and ensure that our country is clean and we are not grey-listed, as you are told. We also passed what is known as the conflict of interest law. It's an act of Parliament now. Another very important act on corruption, because corruption would start with the conflict of interest. I have an interest in the matter, it's a lucrative matter, I don't declare it, I don't recuse myself, and in the process, the country suffers loss. This is why that very strict law, which the drafters, we never knew who they were, but it came to us as a bill. And we try to make it softer. I can assure you, everything we proposed was rejected by the president. And he has power to do that. Again, the checks and balances, where the executive now becomes a legislator. So it was rejected, and we were told if you want to overturn the presidential rejection, you have to raise 2/3 of your numbers against. In that house, it is just impossible. You cannot raise the 2/3. So we couldn't raise the 2/3, and it passed as it was. It's a very stringent law. If it is enforced to the letter, then we would really have to fight 50% of the issues of corruption that we have today. Then from there is what would be the viable interventions to strengthen the fight against corruption? Because this is where you now call upon Parliament to stand up and be counted amongst all these other institutions. It's not just to complain, but we must also help the judiciary try and remove the backlog on cases of corruption, delays in case management, etc. We must assist the DPP to ensure that he has enough state counsel to prosecute these cases. We must assist the EACC, ensuring that it has enough investigators to investigate thoroughly, pass over the matters to DPP, and the matters are prosecuted. We know there may be issues in between, because first and foremost, why do we have to have everybody doing something independent of the other? Purely human rights, that was the argument in 2010, that the investigator should not prosecute. The investigator must do a thorough job in ensuring that the person to be brought to book will actually be brought to book. So the investigator does investigations, the prosecutor looks at it and says, yes, I'm convinced beyond a reasonable doubt that you've made out a case, and I'll prosecute this person. That way it becomes easier for the judiciary to now convict that person. There have been arguments on how this can be modified, but that I'll make a recommendation to you to think about. But what do? We empower the relevant criminal justice sector agencies to act on the recommendations in the reports of the National Assembly. So whenever we do oversight, we make recommendations, and those recommendations are taken to the agencies. So yours would be to carry out those recommendations. Then the other thing we can do is to try and protect the whistleblowers and witnesses. Remember, as we said, corruption is a dragon. It's too huge. It has the power, it has the energy and the ability to corrupt itself and its way around. So if you don't protect whistleblowers, the persons who come to us and reveal what is happening, or the witnesses who will testify in court, then you cannot succeed in corruption cases. We have to ensure these people are immune to everything, just the way we should also ensure the prosecutors and the investigators from EACC and the judges and magistrates are also protected. Because in those failed states where corruption thrives, you find it is not very good to talk about. We had a witness protection bill which was brought to Parliament by a private member, Irene Muthoni Kasalu, and unfortunately it didn't go through the session, it lapsed. We have to renew it. The Attorney General was also supposed to bring another one to marry with that one, but we are yet to see it. But these are the important legislative actions which we are recommending and which must actually be undertaken to ensure we move on. Digitization and open contracting, this is the e-procurement which the government introduced. There was resistance from everybody. Members of Parliament were actually the leaders in this because of small things we do in the constituencies, or which are done in the constituencies. We are not the ones who do them. They are so tiny that you cannot subject them to such a grandiose process. And to flex our muscle, we actually annulled that circular, which had introduced e-procurement. Eventually it was agreed. While that is going on, we can modify it and execute it. We think it's a very, very good process where we go to open tendering and try it, open contracting, and try to protect what we do hand to hand. But the CDF things that happen down there are so small that we feel sometimes they bog down development through bureaucracy. But we are working on it. We are part and parcel of everything that is happening, and we must also embrace the e-procurement. Enhanced interagency collaboration, we've talked about this. It is vitally important that, especially the three agencies that deal with corruption, the EACC, the DCI, and the ODPP, there must be absolute enhanced collaboration between these three agencies to ensure that the work that is done is seamless, it's flawless. It is work that will go to the judiciary when it is ready, it is ripe, and the judiciary will actually come to no other decision than to convict. We know there have been issues. And in fact, I was discussing with my friends from EACC that sometimes it may be worthwhile giving them prosecutorial powers so that when they investigate, they also prosecute, as happens in some countries. The reason given is that every information, every analysis cannot be on paper. Sometimes it is internalized in the prosecutor's mind. So when he goes to court, he is able to say a lot more than what is on paper. As I discussed this with them, I had to draw their attention to the constitutional provisions regarding the establishment, the mandate of the office of the DPP, which is an independent office. So we may have issues with this, but it is not lost on that. What happens in other jurisdictions? I think EACC, you need to look at it this way, so that as we go along, if it is something that can be done, then we can consider it along the lines of what happens in other jurisdictions. Would we need a constitutional amendment or an amendment to the acts? The two acts would be sufficient to cover prosecution that way. There was also mooted that the ODPP should be accommodating so that we have divisions into which he can take counsel from EACC as prosecutors to be prosecuting corruption cases. That again sounds meritorious, and we may be able to circumvent the constitutional provisions by possibly having a division in ODPP which deals with corruption cases, and it has a specialized counsel who are able to prosecute successfully these corruption cases. So as we conclude, Parliament's oversight role is not policing. We are not policemen. Remember, the three arms of government are interdependent. We are not independent per se. We must work with one another. We must support one another. It's not a question of we are independent, therefore we don't take anything from anyone else. It is, we must work within a system which is conjoined. So, as we do this, then it is for you agencies to sit down and propose what you consider to be the best law. Bills, proposals to acts of parliament, constitutional amendments are extremely difficult. The only one that went through the National Assembly was to entrench the CDF in the Constitution. It went through with an overwhelming majority, and you know the reasons. You try anything else, you'll never get 2/3 majority. That we have tried on gender rule, on many, we cannot just get that majority. But there may be a way of going around it through acts of parliament, which require simple majority, or through regulations that just require a committee to pass, and we achieve what we think is the best law to combat corruption in the country. those very many remarks allow me to stop there. And this is a session. If there are any questions, I will take 2 or 3. And then after that, kindly allow me so that I'm able to do the other things in the afternoon and join the other team in Malindi as we continue the public participation. Thank you so much. Thank you, absolutely. Thank you very much. Thank you, lady. From here? Yes. No, do it from here. I can do it from here. Thank you. Thank you very much. Do you want to say anything before?
Yeah. Thank you very much, Honorable Murugara, for your time and that session. Let us appreciate Honorable Murugara. He has graciously agreed to take a few questions. So kindly, if you have any question to Honorable Murugara, you can put your hand up. Thank you. Do we have mics? Is a hand there?
Yes. Can we?
Thank you for your presentation. My name is Elizabeth Duya. I work for Transparency International Kenya. Recently, we did a study on political economy analysis, really focusing on leadership and integrity in Kenya. One of the findings that came out of that particular study is the aspect of state capture or political interference in terms of working with Parliament. I would like to hear your views about the constant interference of parliamentarians in terms of executing your mandate. How are you navigating that, considering this particular workshop is looking at really way forward in terms of how we navigate the space on anti-corruption issues? Thank you.
Thank you. I think let me answer that so that then I take the next one. You'll just be considering it. Capture. I don't know whether that is the right word to use because I ended my speech by saying we are interdependent. It means the executive must work with the parliament must work with the judiciary must work with the executive must work with the judiciary. Part of the problems we have and what concerns Kenyans is the fact that Parliament seems to be taking instructions from the executive. And therefore, they say Parliament is not working independently. But unfortunately, Parliament and the executive are also conjoined to some extent. Government policy is common to the executive and to Parliament. Remember, when we go around campaigning, we have things called manifestos, into which you make promises to Kenyans. Those promises have to be fulfilled. And those promises, 99% of them require legislative intervention. Therefore, whichever way you see it, the executive must originate the bills, and those bills must be brought to the House. And that is the reason why Parliament recognizes majority and minority. Majority would actually be on the side of the executive. And that is the reason why the executive's bills pass. Many of them do not fail because they encompass a policy that is common to the executive and to the judiciary. So that is why your study shows, and it has always been like that Parliament seems to be subservient to the executive, which is not the case. Because where the executive overreaches, Parliament is able to stand out and call the executive to order. That is the reason why you find sometimes the executive is not very happy with the judiciary because they think the judiciary is overreaching. But again, the judiciary is there to interpret the law and apply it as it is. So, there will always be that complaint that of the three arms of government, the legislature and the executive may be closer to one another more than the judiciary would be. And that is how it's supposed to be. Because the excesses of the executive, the excesses of the judiciary, the excesses of the legislature must be checked by the judiciary. So, to some extent, yes, there may be what on the face of it looks like capture, but it's purely because of policy, government policy, which is common to the executive and the legislature. Yes, thank you. Another one?
Thank you very much, Mheshimiwa, for your presentation. I really liked your pragmatic approach to looking at the issues, particularly with respect to prosecutorial powers that can be given to investigative agencies. In particular, the anti-corruption effort, really, we need to look at it and see what is working and what is really not working. And you did actually mention that sometimes prosecution is not just on paper, and it's in the mind of the prosecutor, which I think is something that is really fundamental, and we need to really pay attention to that. Every time this issue about giving prosecutorial powers to agencies like the EACC, the refrain has always been that this is a constitutional prerogative of the DPP, which is true. But at the same time, there is a claim that if we want to give other agencies that power, then there would be need for an amendment to the Constitution. But I'm looking at Article 157(2), which actually gives, is a clause that empowers Parliament to enact legislation allowing bodies other than the Director of Public Prosecution to prosecute offenses. Now, in my own layman's mind, I believe that will require just a parliamentary legislation. It doesn't require a constitutional amendment per se, which of course, as you indicated, is a tall order because getting the 2/3 majority is not an easy thing. So I just wanted to get your take on this. Is this? I believe the framers of the Constitution also realize that it may come a time when it is necessary to do this. And this is where now Parliament would probably come in and say, well, we look at the issue of corruption. And the EACC obviously does a good job. I mean, I chair the Enforcement Committee. And as the chair of the EACC indicated, we look at the work that has been put into the prosecution, into the investigation, the evidence analysis. And that committee actually recommends that these cases need to go forward. And that takes a lot of effort. So when cases collapse or they don't proceed beyond the DPP, obviously it's a wonder. Sometimes you get frustrated. You look at the faces of those who are putting the effort in investigation, evidence analysis, and they get really frustrated because they have done their best, they've given them their best shot, and yet these cases don't proceed. So just to get your take on this particular provision, Article 157(2), if it is really a viable option for going forward in this effort. Thank you.
Thank you very much. Two things I need to observe from that is, number one, it's very frustrating when investigators put a lot of effort, spend resources, and then cases collapse. But again, that mandate is given to the DPP. Is the one who determines which cases to proceed, which cases not to proceed. We need to read the Article 157 also, 1 and 2, so that we see what is the provision in 1, so that we look at how 2 fits in. But if that is the case, then there's no reason why EACC should not have come up with a draft bill. We look at it, we see whether it meets the constitutional requirements, and we process it for you. Because really, Parliament may not be able to initiate the bill. The executive also may not do it. But there's nothing stopping EACC from coming up with a bill which we can look at, process, and we can move it to Parliament even as a committee bill, which means it takes a second precedence. After the government bills, committee bills are number 2, and the private members' bills are number 3. So you may need to look at the whole of that particular article, see if it fits your case, and then come up with a legislative proposal which we can look at. Thank you.
Thank you. We'll take one more question. Okay. There are no more questions. Again, let us appreciate Honorable Murugara.
Thank you.
Thank you very much
Thank you very
for your time. I call upon Mr. Moe.
Let us appreciate the presenter, Honorable Murugara. And let us also appreciate our Vice Chair, the moderator. At this point, let me invite again the Vice Chair and the Chair Enforcement Committee, Commissioner Ogalo, to come and present a souvenir to the Honorable Murugara. Farida, you bring the souvenir. They are all less than 20,000.
Thank you.
Commissioner, you can go the other side. Commissioner, you can go the other side. Thank you very much. I think we have processed that first session with a lot of efficiency. I think we have been able to meet the request by Honorable Murugara. So I appreciate all of you. Allow me to make some announcements. We will be proceeding to second floor for a group photo. The I table, that is the chief guest and his accompanying party, will be the first to leave the room to second floor, and the protocol team will guide to where we'll be taking the group photo. Then the rest of the participants will follow members of the I table. When we get to the second floor, after the group photo, again, members of the I table, there's a media center which has been set up there. You will remain there so that you do a short press briefing. When the members of the I table bring the press briefing, all the other participants are requested to come back to third floor where we are and take their tea. The tea is served to this is my left or right? I'm left-handed. Sometimes I'm not. To my right, the extreme door, that is where tea is served. After the press briefing, members of the I table will take their tea in the holding room where we did the briefing in the morning. And the next session will resume at 11 o'clock. So that is the order of event from here. So members of the I table, I request that we leave for the group photo. Protocol, Farida, you can guide. Yes. Okay. I think the rest of us, we can follow to second floor.
Mic check.
Check 1, 2. Check 1, 2.
Mic check. Mic check.
Check 1, 2, 1, 2. Check 1, 2, 1, 2, 1, 2. 2. Check 1, 2, 1, 2. Check 1, 2, 1, 2, 1, 2. Check 1, 2, 1, 2. Check 1, 2, 1, 2. Check 1, 2. Check 1, 2, 1, 2, 1, 2. Check 1, 2, 1, 2, 1, 2, 1, 2. Check 1, 2, 1, 2, 1, 2. Mic check 1, 2, 1, 2. Check 1, 2, 1, 2, 1, 2. Check 1, 2. Check 1, 2. Check 1, 2. Check 1, 2, 1, 2. Check 1, 2, 1, 2.
Okay, good to see all of you. My name is Nimro Tabu. I work for the Royal Media Services as a TV presenter, but I work closely as well with ESCC for some time, couple of years now, and I really appreciate. So once again, karibuni sana, and we're going to have a really wonderful discussion. Mkiona nimesimama pale hapa, huwa napenda kusonga songa, all right? So that we have an engagement that is very, very efficient, very lively, and we take something home from here. Sindio? Being the first day, isn't it? So I'm going to be engaging you. Even though I'm going to engage the panelists more, I'm going to be engaging you. Sawa sawa. So ukiona microphone imekuja kwako, ujue nataka comment au swali. Sawa sawa. All right? Once again, good morning and thank you so much for being here. All right? I want to invite our guests, na kwa sababu ile session ya mapema ilikuwa na waume peke yake, sio? Naona vyema nianze na bas. Sindio, eh? They say ladies first, okay? So here goes. It's now 11:05. We have about 2 hours for this session, all right? And I hope it's going to be lively so that we all engaging together. She has over 28 valuable experience years working for women, socio-economic and political empowerment, programs in Kenya, mobilizing women for sustainable livelihood initiatives, including forming women and business associations, raising women's awareness on economic opportunities in Kenya, coming up with innovative ways to promote MSMEs in this wonderful country. She is currently the executive director of KEPSA Foundation. KEPSA Foundation is the social arm of KEPSA Business, and it works in 5 priority areas. 1, which is fostering governance and national value system. 2, the community climate action and sustainability. 3, empowering of women, youth, persons with disabilities, and childcare. 4, communities outreach and partnerships. And 5, Knowledge Institute and the think tank. She has been very instrumental in both policy formulation and establishment of lactation spaces in the private sector. She is currently leading the private sector in establishment of orchards in schools under the climate conservation practices and strengthening food systems. She has also worked for the UN at the International Labour Organization for close to 9.5 years, during which she coordinated the ILO Kenya Women's Empowerment Program, WEDGE, and headed the Women's Economic Empowerment Priority of the UN Joint Program for Gender Equality for 3 years. She was a signatory of the ILO Kenya account and a member of UN Women SRO Project Advisory Committee. Distinguished delegates, would you be kind enough to help me welcome on stage Madam Gloria Ndekei, OGW. Karibu sana, makofi kwake. Thank you so much for making time. Musichoke kumpigia makofi, mpaka angalau aketi. Ajisikie huru na vizuri kabisa. Karibu sana, Madam Gloria. We appreciate your time. Thank you so much, and we're going to have a wonderful, wonderful discussion. All right. She's an advocate of the High Court of Kenya and Uganda with over 8 years of experience in governance, human rights, and anti-corruption work. Currently pursuing her master's in gender and development studies in the University of Nairobi. She works at Transparency International Kenya, where she leads in coordinating the Citizen Demand and Oversight Program, which focuses on advocating for the implementation of Chapter 6 of the Constitution on Leadership and Integrity, Access to Justice, and strengthening the capacities of citizens, local grassroots organizations, and civil society organizations to demand good governance, transparency, and accountability from government. Through her work at the Transparency International Kenya, she has made major contributions in various areas like Lead TI Kenya through its advocacy and legal advice centers, coalition and movement building, engaging various local and national civil society, and also in matters research and knowledge management, where she has contributed to the development of knowledge products for TI Kenya, including the generation of the UNCSC Parallel Report 2025. Ladies and gentlemen, would you be kind enough to welcome on stage Madam Elizabeth Duya to come and join us as a panelist. Karibu sana, Madam Elizabeth. Msichoke na makofi jameni, msichoke kabisa. All right. So the next panelist I want to invite on stage has carved his path through legal jungle to become a towering figure in ethics, governance, and the law. Admitted to the High Court of Kenya in 1991. He built Mwaniki Gashoka and Company Advocates in 1993. In 2022, he was appointed a judge of the Court of Appeal and served as vice president of the Appeal Judges Welfare Association. He is a crusader for integrity and left his mark at the EACC between 2016 and 2021 when he helped to fearlessly tackle corruption. Ladies and gentlemen, this wonderful gentleman hails from the misty slopes of Mount Kenya, a place called Chinga. He's, as I said, a crusader of integrity. He is a fellow of the Chartered Institute of Arbitrators and a chartered arbitrator. He has shaped the arbitration landscape with a keen eye for justice. His master's in philosophy and ethics has seen him dissect public procurement oversight and surgical precision, seeing him defend his thesis dubbed Public Procurement Oversight Authority. Ladies and gentlemen, would you be warm enough and kind enough to put your hands together for Mr. Justice Gashoka Mwaniki. Karibu sana. Karibu sana, tunasema asante kwa kuja kwako. Mmemaliza makofi mapema, jameni. Last but not least, ladies and gentlemen, prior to his appointment, he was the Deputy Chief Executive and also served as a Director in charge of investigations at the Commission, which is EACC, for over 10 years. He is an advocate of the High Court of Kenya and a seasoned investigator with a wealth of experience spanning over 30 years in investigation of corruption and other forms of economic crimes. He started his law enforcement career in 1989 as a cadet inspector at the Kenya Police Service. Believe it or not, he was a police officer. Makofi kwake. He later joined the Kenya Anti-Corruption Commission, then KACC, in 2005. As a senior officer in charge of Rapid Response Division and rose through the ranks to head the Directorate of Investigation. He has undergone an expansive training for the years as a career detective in corruption and economic crimes, both locally and internationally, with various distinguished law enforcement agencies. While serving as the Deputy Chief Executive Officer, he was responsible for deputizing the Secretary or Chief Executive Officer, EACC then, in the discharge of his statutory advisory, administrative and policy responsibility in the daily operations and management. Ladies and gentlemen, would you be kind enough to put your hands together for Mr. Abdi Mahmoud, MBS, the Chief Executive Officer, the Ethics and Anti-Corruption Commission. All right. Thank you so much. I'll be joining you right now. And I'm being told that we are live on X and also on YouTube. Karibuni sana. I know this is a serious discussion, but on a lighter note, I hope none of you is an Arsenal fan. Football club. Anybody who's a football fan of the Arsenal Football Club? Tuachie hapo, tusiendelee sana. Haya mambo mengine, but at least put on a lively face, all right? Okay? I know it was, but they bado wako na matumaini, all right? So here goes, ladies and gentlemen. I know I haven't done a lot of justice to your introductions, all right? So in case you would want to amend anything or correct me, you can do that in just about a minute, but I'd like to follow up with a question so that when you get the opportunity to introduce yourself officially to the audience, then you can proceed to answer my question, which is a general question, which we begin with, all right? As I said, mentioned earlier, we have various questions for the representatives here. And my first question is that Kenya has made significant progress, no doubt, in strengthening anti-corruption laws and institutions. But here's my question. Why does the public still feel that corruption remains widespread? And what must change to move from progress to real impact? May I start with you, Madam Gloria?
Thank you very much. Mr. Nimrod, I think that was sufficient for today. My name is Gloria Ndekei, Executive Director for KEPSA Foundation. We are a baby of KEPSA industry, where the membership of the private sector sits as the apex body. In relation, and going straight to the question, I think I would really look at corruption in the private sector and maybe relate it to the public is still feeling that not much has been done. If I attempt to answer that, I think the public would feel that probably not much is being done because probably they are still getting unnecessary inflated consumer prices. And this probably is as a result of corruption in the private sector or perceived in the private sector, which maybe translates from the cost of corruption being input on the cost of production. The public sector, so to speak, even from an international point of view, is still feeling there is decreased foreign direct investment, where probably the investors are not able to get so attracted because of the cost of probably starting businesses in Kenya. The public still feels that there is the pinch of the cost of taxation as a result of probably tax evasions from a number of people who are doing businesses. The net is not cast as wide, and therefore a number of private sector companies feel that that taxation is a bit heavy on them. And of course, there is still a lot of, let me not say a lot, but uncertainty of economic transactions, and therefore the level of investment. Sometimes people hold back because they are really not sure what's going to happen next and what is the next cost that may be incurred by the companies. Is that okay for now? Yes. Yeah, thank you.
Yeah, thank you. I think that is a very good question. First, let me say that corruption is not a problem only in Kenya. It is a problem all over the world. But our concern is here, where we are, our country. And the reason why most Kenyans feel that corruption is still a problem is, in my view, they would like to see more people arrested. They would like to see more people prosecuted. They would like to see more people jailed. That is the approach the Kenyan public would usually address when we are dealing with corruption. Our experience has been that we are not so much interested in, how to prevent corruption, but we are so much interested in ensuring that people who steal are punished, which is the right thing. But again, it's not the only thing that needs to be done. And I think we've also had a situation where, as everybody would remember, the people would always say, we want blood spilled. They want to see blood. Blood meaning they want to see people jailed. And unfortunately or fortunately, we do not have many people jailed. And that is one of the reasons why we are here, maybe just to discuss in the investigation process, where do we go wrong? Is it that we are not collecting sufficient evidence to get a watertight case so that people are prosecuted and convicted? Is it possible that probably we are not prosecuting as we ought to? Or is it that the cases are not being addressed in court as they ought to? But in my view, Kenyans view the fight against corruption from a law enforcement perspective. Thank you.
Thank you, Banasio. Justice Gashoka, same question. And from the judiciary standpoint, why do you think the public still feels that corruption remains widespread? And how do we move from progress to real impact?
Okay, thank you, Nimrod. I think, let me first of all say, this topic is a very important topic for us as Kenyans. And the first question we should ask ourselves, that perception by Kenyans, is it right or is it wrong? And maybe, because that is the starting point.